Good afternoon, everyone. This is Lane Kelman. I am a partner at Cohen Seglias. I'm here with Matt Skaroff.
Hello, everybody.
We will be putting on the Construction Defects Lessons Learned seminar today. Some housekeeping matters first. For anyone that is tuned in, there is a link on the webinar for a handout section. Feel free to access that. In addition, you have the ability to ask questions during this seminar. So plug those questions in during the drop down, and to the extent that we can get to those questions during the course of the seminar, or the webinar, I should say, then we will do that. There will also be a short Q&A section at the end. If we have enough time, we'll address it then. And then lastly, if there are questions that for whatever reason we cannot get to during the course of this webinar, or we think are more appropriately answered away from the group, we will follow up after the webinar. In addition, the webinar will be available both by way of handouts, as well as you can listen to it, the audio, at a later date.
Yeah, we'll be making a recording of this session. We are live.
We are live now. Matt and I, as we sit here today, and I can confirm that we are in fact sitting since no one can see us. As we sit here today, we have over 11 construction defect matters ranging from geographical areas and jurisdictions of Virginia up to PA and all the way out to Salt Lake City. And they predominantly are focused upon vertical construction matters. However, construction defects are not limited simply to vertical construction. They can involve many different projects, regardless of type of construction. But today we're going to be focused for the most part on vertical construction, but there will be scenarios that we address that are outside of that.
So just to give you a breakdown of what we're going to get into today, the first question, the fundamental question is, what is a defect and how is it defined? And we'll be running through a couple different ways and theories of looking at defects. Once we establish that, we're going to move to defects under the A201, the general conditions for the American Institute of Architects general contract that is used on many projects, and see how that addresses defects. Once we move through there, we're going to look at protecting yourself with contract terms and negotiations. If you're an owner, if you're a general contractor, how can you amend standard construction documents to best protect yourself? From there, we're going to go into defects and insurance and the interplay between those. We're going to look at defenses to defect claims after that. And then, given our experience, we're going to take two perspectives from cases that were actively litigated and are now concluded. One from an owner's perspective, where defects were a significant issue in the project, and one from a general contractor's perspective. And then finally, we're going to wrap it up with some points to remember.
Now, that's a lot to cover in 1 hour. We recognize that some things we'll certainly gloss over. If there's any particular topic that you want to hear more of, either generate a question and we'll hit that during the course of the webinar. We'll follow up. We are going to be using as a template the AIA. The reason why we're doing that is I think across the industry, it is well known. Most people use that as a starting point, so we're going to focus upon that as our starting point. That does not mean that we are endorsing the AIA or believe that it's appropriate to be used for all projects. I think it is a good neutral starting point, and you use that as a potential template depending upon where you fall in the construction chain.
Make sure you always review your contracts, folks. Important piece. All right, so the first piece, what is a defect? We found 5 general categories that we thought captures the different types of defects that can arise. The first type that we saw are materials and equipment furnished is not of the quality required by the contract, or it fails to function properly. So to give you 2 examples, we had a case where there was a performance spec for a HVAC system. When it was finally installed by the contractor, it did not maintain consistent temperatures required by the performance spec. That would be a defect. Another case we had involved a sewage pump that had to have a certain amount of suction. When it was installed and supplied, it did not have that suction. It was a defect that failed. It was a construction item that did not function properly, and it did not meet the quality required by the contract. Second type, work is executed in a defective manner. Simply, it was not performed properly. Example of this, floating wood floor. If you're familiar with that, it is not supposed to be affixed to anything aside from the floor itself.
Otherwise, it's not floating.
Nailed to the subfloor, the opposite of a floating floor. That is just simply defectively performed work. Third side, the work, while executed correctly, does not conform to the contract requirements. Kind of abstract example for you. PVC pipes for plumbing. They're correctly installed, they work, but however, the contract documents call for copper pipes.
I currently have an active case right now where the specs called out for CPVC, and the contractor went and installed PVC. And we'll touch on the implications of that later, but as we sit here, the project and the system is functioning properly, but the owner and the general contractor did not get what they bought. So there's implications that arise from that. And
just as an aside, the difference between these types of damages has some implication down the line on, number one, who's responsible for these defects, and then number two, the recoverable damages that are connected with them. And we'll get into all that a bit later. So another type of defect, the construction meets the contract requirements, but it violates building code. So example of this that Lane has had, he had a client who built totally in accordance with the contract documents. However, the setback requirements were not followed and it didn't meet code. And a final defect type, the design fails to meet professional standards. Example of this, the architect, for example, or engineer failed to consider the solar loads on the building, ultimately resulted in overheating.
Inconsistent and patchy HVAC throughout each floor of a structure. Now, both of these types of defects are important. It's important because they can in turn dictate the relief that you're looking for. When you take a look at a construction defect, they fall within two categories. Sometimes they may overlap a little bit, but you're going to have in most of those types of defects, construction defects or design defects. When you're categorizing those, you're often looking at trying to determine what the target may be. And the target can fall back on not only the type, but also the relief that you're looking for. So when we get a case or a potential case, we're looking at the type of defect, and then from there, we're trying to understand who are we representing and who is the target. Now, a very big difference in construction defect cases versus a traditional construction dispute is in the construction defect case, you have multiple players, not only those that may be responsible, but those that stand behind them. And by that, insurers. You don't necessarily need to have an insurance carrier behind you or behind the target, but that's a consideration that should be analyzed and thought through completely. Because depending upon how it is, if this gets to litigation, one frames a complaint or frames a counterclaim or whatever the case may be, you may or you may not invoke insurance coverage. Sometimes you want the coverage, sometimes you don't. As opposed to a straightforward construction dispute, when you're looking at scope of work disputes, a lost productivity or delay, there's people behind the architects, people behind the subcontractor or supplier that may be making the decisions as to whether to sign the checks or not. Those are the insurers, the adjusters, et cetera. So there should be thoughtful consideration given when you're analyzing the type of defect as to the type of claim or defense that you want to raise.
And as an additional point on this, the concept of privity, meaning contractual relations between the parties, is going to dictate who can be sued and who can be held responsible. And where you fall in that chain is going to prevent you and enable you to go after certain people in order to recover for a potential defect. If you're an owner, you're generally going to be precluded from going after the GC sub for a defect that sub caused. The owner is going to have to go after the GC. And then, in turn, the GC might be precluded precluded from going after an architect or an engineer, albeit in certain circumstances this is possible. But the chain of contracts is really going to dictate how the action moves in large part.
Now, what Matt just said is reflected on slide 9, in that you have the owner GC matched up against one another, and then in the red at the bottom, you have the sub-supplier manufacturer, and that's the chain of privy that Matt's referring to. Oftentimes, you are married to that chain of privity, meaning you can't go outside it, but depending upon the jurisdiction you're in and necessity, you may potentially get around that. You see in the owner end, it's the owner holding the contract with the architect, who you would hope the architect holds all the A&E sub-consultant contracts. That doesn't always happen, and that could create a mess sometimes. But if you're a GC and you are asserting a claim against or defending against a claim, you're going to be looking downstream, whereas the owner can look both on the design end and the construction end. Excuse us while we try to jump a slide.
Clicker seems to be used manually. There we go. All right, so now that we've covered the various types of defects, we're going to look at defects and how they're treated under the AIA A201, 2017 we're looking at. I'm sure some of you are familiar or have seen this document. So the first section we're going to look at is section 2.5, which covers the owner's right to carry out the work. And this applies during the project and during the warranty period. Generally, under 2.5, if a defect arises, the owner has to give the general contractor notice and opportunity to cure that defect. So once the owner is aware of a defect, informs the contractor has 10 days during the project to come back and fix that. If the contractor fails to do so, the owner can then go and take correction into its own hands. The owner can charge reasonable costs of correcting. That includes the owner's expenses, compensation to the architect for additional services, testing, inspections, replacement, uncovering. It's not limited, but basically anything that was necessary to fix it can arguably be recovered. Including
if you have to bring in a third-party professional to do an evaluation or come up with remedial work, that arguably is covered within the AIA 201. And that's important because that would be a professional fee that is recoverable.
Now, notably, the architect must approve those costs, and if the architect does approve those costs, monies can be withheld from the certificates of payment to the general contractor going forward. If there's not enough money to cover it, the owner can pursue a claim for any remaining costs. And if the contractor disagrees with the assessment of how much it costs, the contractor can submit a claim and challenge that.
Now, as we'll talk about a little bit later, that withholding is important, not only as leverage, but also you need to keep in mind, should you get to the point where there is a withholding, if you're an owner that's making withholding and or a GC that's withholding a subcontractor downstream, that withholding is comporting with prompt payment statutes within the jurisdiction you're in.
Section 3.5 dictates the warranty that the GC provides on its work. It says work's going to be good, quality, and new, unless otherwise specified. It's got to conform to the contract documents, and it needs to be free from defects. Any work that does not conform to the contract documents is deemed defective. However, any abuse, wear and tear, or owner alteration is excluded, and it will not constitute a defect under the A201.
There's a misnomer that I'm often confronted with when I have a owner, developer, or even a general contractor contact me or contact Matt about warranty obligations. And the misnomer is if they have a warranty obligation under the contract of 4 years and something arises outside of that 4 years, that they don't have any obligation to correct or take that on. That is a misnomer. If there's a warranty period, let's say I go back to my example, but not the best example, let's say 3 years. Let's say there's a 3-year warranty period under the contract. A problem arises year 4. If that problem is because you did not comply with plans and specifications, that is a breach of contract. And we're going to touch on the implications of a breach of contract and the passage of time in a little bit. But do not think for a moment that if the warranty period expired, that you're off the hook. It may take away an affirmative obligation to do something to cure, but it does not eviscerate any potential liability.
So as mentioned, under 2.5, we know that the owner can go back and correct work. And Section 9.5 governs the architect's approval and withholding of money to the general contractor for any of those costs. As noted, architect can withhold. The architect has to notify both the contractor and the owner of that amount before going and doing it. So that would give the GC the opportunity to object to that amount. And similarly, the owner could object if the owner feels that it's not sufficient to cover the corrective work. But in most circumstances, I think the owner and the architect are generally going to be in agreement on the amount. And then finally, the architect may withhold future payments based on issues that have been discovered in the past. If there was an issue at the beginning of the project that wasn't uncovered until towards the end of the project, money can still be withheld. There's no real time limitation on that piece.
While there may not be a time limitation, there may be a waiver argument depending upon the situation.
Yeah, and whether that defect the owner was aware of that. And just as side note, 9.5 doesn't limit withholding simply for defects, but it also goes into non-payments to subs, third-party claims, work that can't be completed under the remaining payments left for the contract, work that can't be completed in time and would be otherwise subsumed by liquidated damages. There's other reasons, but 9.5 covers defects. So when a defect is discovered, is going to have implications on correcting. If it's before substantial completion, that is governed by 12.2.1. This is going to be subject to 2.5, which we saw earlier, basically the 10-day notice by the owner. The contractor has to come within those 10 days and fix that work, and the contractor is going to be responsible for the cost of correcting, testing and inspection, uncovering, replacement, architect compensation if there's indeed additional architectural services.
Traditional notice and opportunity to cure.
Now, if the defect arises or is discovered after substantial completion, this is and within the warranty period, the 1-year warranty period, which is standard under the 201, which can be modified, it can be lengthened, but just the standard period is 1 year. If it falls within that 1 year, it's still going to fall under 2.5. The owner has to give prompt notice. Within prompt notice, the contractor has to come out within 10 days and begin work. This is a crucial point right here. The owner will waive the right to recover for that defect if that owner fails to give notice and opportunity to cure.
And that ties into a doctrine that we'll talk about a little bit later, a legal doctrine called spoliation.
So if the owner goes and fixes itself without letting the contractor come out and see it, without letting the contractor have an opportunity to correct at earlier expenses, or just even having the contractor know that there's a defect in the first place, there's arguably a waiver at play.
As well as the mitigation of damages obligation.
However, if the owner gives the contractor notice in accordance with Section 2.5, contractor doesn't come out and start work within 10 days, then the owner can go and start the fix. And as we discussed, contractor will bear the costs. Now, if a defect arises after the warranty period, the 1-year warranty period, then it is subject to a bit of a different treatment.
All right, before we'll talk about the next slide, which is latent defects, the AIA 201 goes a great length to address defects that arise prior to substantial completion, and obligations of the owner under a contractor, and defects that arise or you're on notice of subsequent to substantial completion. The theme is the same in both, in that it's addressing the obligations of the owner should it become aware of a defect to mitigate its damages and not spoliate evidence. Two themes that run throughout any piece of construction defect litigation. Now, in the scenario where, and we talked about this a little bit earlier, when subsequent to substantial completion, a defect becomes known that you did not know about during or should not have known about during the course of construction, that is what is called a latent defect. Now, a latent defect can arise after a statute of limitations. So what's a statute of limitations for those that aren't quite sure? In each jurisdiction, there's a period of time in which you can allege a breach of contract action, a professional negligence action, whatever that may be. And if you are on notice of a potential claim during that period of time and you do not bring that claim, then the statute of limitations has run and you are time barred from bringing a case. Now, if you were not aware and should not have been aware of a claim, that is during the period of time, during the statute of limitations, because the defect was latent, then you can bring a claim outside of the statute of limitations with a big so long as you're within what's called the statute of repose. So using Pennsylvania as an example, you have a 4-year breach of contract statute of limitations, 2-year professional negligence. Say on year 5, there's a construction defect which you became aware of. The statute of limitations did not expire because it did not start to run until you became aware of that defect in year 5.
You gotta make a timeline for this. I'll come out later to be sent. One moment. Go. 15.1.7 is an important piece of the A201, and Lane's going to address it. It talks about consequential damages.
If the waiver of consequential damages, which is standard in the AA201, is a very important provision depending upon the hat that you're wearing. If you're an owner and you have a waiver of consequential damage provision within your contract, then you are losing some ability to recover damages which can arise from a construction defect other than simply the cost of repair. Conversely, if you're a contractor, then you are limiting your liability and vulnerability if there is a waiver of consequential damages provision. Now, the case law, depending upon the jurisdiction that you're in, interprets what a consequential damage is a little bit differently from jurisdiction to jurisdiction. But from an owner's perspective, the standard waiver of consequential damages says that you are waiving lost rental expenses, loss of use, financing cost, income, profit, or even overhead for maintaining those properties. So if there's a construction defect that arises and let's say you have an apartment building that you cannot rent out and you are losing not only that rental income, but you have carrying costs. The contractor, who is potentially liable, or even the designer, because they have the same provision in their contract, who is potentially liable, is going to be off the hook for those damages. So if you're an owner, you need to be aware of that. Now, there are provisions that you can write into the contract that even with the waiver of consequential damages that help protect the owner a little bit, such as a liquidated damage provision, but that will only take you up to occupancy. It does not address a scenario of there being a defect post-substantial completion. So the waiver of consequential damage provision, depending upon the hat you're wearing, you need to be aware of, have command of, and address that from a contract negotiation perspective.
And on that point, if your contract does not include a waiver of consequential damages, that does not automatically mean you would be entitled to recover, lost rental, loss of use, et cetera, et cetera. It depends on the jurisdiction. Pennsylvania, for example, requires that the type of damages be reasonably contemplated by the parties at the start of the contract, at the time of contracting. If a contractor knew that the owner was relying on getting this done by a certain date and planned to rent it out afterwards, and it contains no waiver of consequential damages, there's a decent argument there that it could be reasonably expected that the contractor's failure to complete on time or complete correctly would cause the owner to suffer that type of damage. If it is something that is totally out of left field, for example, we had a case where contractor claimed that they went out of business as a result of the project and they sought to seek all their profit and loss of business. There was no indication whatsoever that that was contemplated by the parties at the start, and therefore it was not deemed recoverable. So just because this waiver is not there doesn't mean you're entitled to those damages.
Yeah, where this law is developing a lot is in the realm of sustainability, LEED building, LEED certification, SREX, obtaining the SREX credits or getting certification, LEED certification within a certain period of time so you could get tax credits and subsidies, et cetera. That's an area that's developing, and the more that you have in your contract that puts the parties on notice, even if there's not a provision that addresses consequential damages, would make an argument stronger that the parties reasonably envisioned, because this was supposed to be a LEED Platinum project and it was dependent upon subsidies, certifications, et cetera, that would create the stronger argument for there being exposure and or recovery.
So some general takeaways from the A201. Generally, the contractor bears responsibility for work that doesn't meet contract documents. The contractor generally must be given notice and opportunity to cure that defective work unless there's a latent defect that appears after the warranty period. Even in that circumstance, it may make practical sense to request the contractor come out and repair. If the owner corrects the work, there's damages include the cost to correct, investigation costs, uncovering costs, architect fees, anything else that was a necessary expense in correcting it. And then finally, consequential damages and attorney's fees as well are generally limited. On the attorney's fees piece, there needs to be an explicit agreement in a contract or some statutory basis to recover attorney's fees. Otherwise, that's not on the table. And one statutory basis, which I assume some of you are familiar with, is Pennsylvania's Contractor and Subcontractor Payment Act, which, Lane, would you talk about the interplay with that?
Most jurisdictions at this point have prompt payment acts. We're using Pennsylvania's just as an example today, but almost all jurisdictions have prompt payment acts. And what it states is, in order for an owner to withhold, it has to do so within a certain period of time, and it can only do so in a reasonable way. That's the theme that runs through all of them. By that, I mean, if you're going to withhold a payment, you have to do so on the basis of a notice of deficiency, which must explain why you have that withholding. And the withholding must bear a reasonable amount in relation to that deficiency. If there's a finding that the withholding was inappropriate, then there's going to be the exposure to attorney's fees and costs. So the theme, again, through the AIA, dovetails with the prompt payment statutes and also dovetails with the mitigation obligation that every party has, that if you're going to take action, you have to provide notice and opportunity to cure, and that notice and opportunity to cure has to comply with statutory obligations.
So, and under this is a new update to CASPA, and there's a note, CASPA only applies on private projects. It's not applied to public projects in Pennsylvania. These changes went into effect just in October. It requires a 14-day period in which you have to send notice and written explanation of what the defects are and why the money is being withheld.
Yeah, we had a question about consequential damages that came up, and if anyone has questions, feel free to shoot those out. If the contract is silent as to consequential damages, then yes, then there will be potential liability of consequential damages. And it gets back to how does a jurisdiction define a consequential damage and proving out the elements from that. So yes, if there's silence, that is, there's not a limitation as to what is recoverable, then the argument is it is recoverable, and in turn, you're liable for consequential damages.
All right, so we're going to move on to, we looked at the standard A201, and as we stated earlier, it can be modified. It's a good starting document, but depending who you are, you may want to change certain provisions in order to put yourself in a better position to protect yourself.
We talked about the withholding percentage. We talked about consequential damages, professional fees, and litigation costs. As Matt said, they're not recoverable unless there's a statute that makes it recoverable or the contract makes it recoverable. If you have a provision in the contract that speaks to recoverable of professional fees, whether incurred in pursuing remedial costs or in a dispute recovery provision. So you're going to have in every contract that's well written, there's going to be a dispute provision. The dispute provision is going to speak to what's recoverable, and it should be the prevailing party. And if the prevailing party has a provision that says only professional fees, then there's going to be an argument that does not include attorney's fees. But every prevailing party provision should have a fee shifting provision that states any and all costs arising from or related to this litigation are recoverable by the prevailing party, and that covers you. There's also a provision that you could write in that states any professional fees, including attorney's fees, incurred in collection of or pursuit of the remedial costs can be recoverable. So it's all about the tailoring of the contract.
And notably, as we saw with the A201, your fees to your cost to investigate a defect and have somebody come out and say this is what needs to be done to correct it, that is contemplated by the A201. However, if you go and get an expert witness for a case, for example, that arguably is not. And if you put in recovery for professional fees, that might expand that, at least your grounds to say that, yeah, my expert witness is covered in court, the cost of that, as well as the cost of investigating on the job. An additional piece, these 2 points at the bottom.
Yeah, so there's a distinction, as Matt was noting, between factual witnesses who are necessary to investigate and develop remedial documents versus litigation fees or expert witnesses. Unless the contract allows for the recovery of expert witnesses, which are going to be distinct and separate from fact witnesses, you're not going to have the ability to recover those costs. Now, the next point that Matt was getting to, the second to last bullet point on the screen that we're looking at, screen 28, is aligning the dispute provisions. That's a very crucial point, particularly if you're the owner. Oftentimes, the owner is going to hold the contract of a design professional who in turn is going to hold all the other subconsultants A&E contracts. What if the design professional has an arbitration provision, but the general contractor has a litigation in court? You have provisions that don't marry. The standard AIA default is arbitration. If you have a contractor that negotiates out with the owner contract where a dispute after mediation winds up in court, and the architect may be responsible for whatever problems arose, you're going to be litigating potentially in two different fronts. So you should have the ability, if you are dictating the terms of the contract, to in turn dictate where the dispute is going to wind up. There should be marriage dispute provisions, so you are all in arbitration or you are all in litigation, or if you have the ability under the contract to dictate where you are, to be able to divide and conquer that way as well. So from a contract negotiation standpoint, look at the dispute provision, and ideally you want to be able to say to your subcontractor, to whomever it is, at the discretion of you will choose arbitration or litigation.
Fighting on two fronts. Didn't that take down the Roman Empire?
They weren't well funded enough.
if you find that yourself in that situation, though, it can be made to work. It's just not ideal. All right, back to topics. We're looking at now defects and insurance. And just as a preface to this, I note that we have a department here at Cohen Seglias that has expertise in insurance. And while Lane and I routinely deal with these issues, they are tricky and they change on a jurisdiction by jurisdiction basis and a case by case basis.
And a policy by policy, endorsement by endorsement basis.
Indeed. So Pennsylvania has a uniquely strict standard for insurance coverage for construction defects, so much so that Pennsylvania's leading case, which is Coverner, is sort of the term of art in the insurance industry. Certain states, if they resemble Pennsylvania, are called Coverner states, I'm told. Generally, the idea behind Coverner is that faulty workmanship by a contractor itself is not covered by insurance. If a contractor builds a building and the thing falls down because it was improperly constructed as a whole, with no other outstanding issues, insurance is not going to cover that. That is just simply the contractor's faulty work for which the contractor bears its own risk. Pennsylvania has extended that a bit. There's a case called Gambone, which basically says that the reasonably foreseeable consequences of defective work is not covered under an insurance policy. In Gambone, that involved windows that were installed on new construction. The subcontractor put in improper flashing around the windows, which resulted in water infiltration, which later resulted in mold down the line. And the contractor was on the hook for it. Insurance would not cover it. As a result, the insurance companies have come up with a workaround, which is a endorsement specifically. If you have that in your policy now and you find yourself in a Gambone situation, the defective work of your subcontractor, which causes on a single piece, the windows, which causes damage to another piece of the construction, for example, the interior of the home, that would be covered. And the insurance company in turn would probably subrogate and go after the window installer. But at least there is an endorsement carved out in the policy. With that being said, you have to pay for it. You have to explicitly request it. It is not going to be there by default.
So what does that mean practically? That means regardless of what jurisdiction, and I don't care whether it's Pennsylvania, Virginia, Utah, whatever the case may be, you need to understand what the insurance requirements are. That is, what is the owner dictating? The owner needs to know what the exclusions are, what the exceptions are within its jurisdiction, so there is ample coverage. And when you get the contract requirements, as a general contractor, you want to make sure that your broker's reviewing it, but from a subcontracting perspective, you need to make sure that there's adequate coverage that requirements that flows downwards. Whatever it is you're buying, endorsements that you're buying and that the owner is requiring, you need to make sure that the subcontractors are as well. Because if not, you're going to have liability. There's going to be potential exposure there.
And to contrast Pennsylvania with another state, you go over the bridge, over the river to New Jersey, where there's a WIDO case, and that's similar to Coverner. Basically, if it's faulty workmanship and the work itself is damaged, contractor builds a building falls down because it was poorly built, that is going to be excluded. However, where Jersey differs, the same situation as the Gambone case, leaky flashing, water infiltration, the interior of a building gets damaged, that is going to be covered. That's an accident, wasn't intended, and it will fall within the scope of a policy. But moving away from general commercial liability, there is builder's risk insurance, which covers accidents to the project during the construction. If a building is being built, we're halfway through, it catches on fire because of some occurrence, that would be covered by builder's risk. It can either be the owner or the GC that purchases it. The contract will usually dictate who has that obligation. And then finally, there is a pollution policy. It's an endorsement or a special policy that you can get, cover environmental issues, mold on the project, mold as a result of work. Anything to add to that, Lane?
We'll touch on that policy when we talk about one of the examples. But the pollution policy in particular is a low-cost, high-protection policy that everyone should be looking at, and the owner in particular should be requiring and GC getting.
All right. Next section that we're going to touch on is defenses to defect claims. Just a couple to list out. We'll touch them all in one-on-one, but no defect, defective design. It's not the construction that's defective, it's the design. There's a failure to mitigate. There's spoliation, there's betterment, there's economic waste, and there's many other things in the background, aside from these six.
All right, now before you get to the defenses to a defect claim, there's some things that we ought to just reemphasize. The point that we're trying to drive home from going through the 201 and the other slides is when you become aware of a defect, you have to take some timely action. If you are the recipient of a notice because an owner or a general contractor took timely action, not only are you going to start putting together some defenses, but you should immediately notify your carrier to see if there's potential coverage. If your carrier and in turn yourself are going to start putting together a defense, and these bullet points that we're going to hit on now are the primary defenses that carriers, general contractors, subcontractors, or even design professionals will emphasize. They come up again and again and again.
So first defense, there's no defect at all. I'm a contractor. I built the building as required by the contract documents. Anything that resembles a defect is not a defect in my work. It is purely a defect somewhere else. It's normal wear and tear. It's lack of maintenance, improper operation. We talked about the sewage pump earlier that didn't seem to have adequate suction. It could simply be the owner's failure to adequately operate it, which is causing something that resembles a defect.
Yeah, the lack of maintenance is one that comes up almost routinely with parking garages, particularly those, the Mid-Atlantic, Northeast region. Yeah, they should have, at a bare minimum, amongst other things, what's called traffic coding. But if you don't have a maintenance program, even if there's a lack of traffic coding, you're going to get, over time, because of salt that's used to treat ice and snow, et cetera, that's going to penetrate the concrete. It's going to cause the rebar and structural steel components to decompose over time. So when you have a garage failure, a lot of times you're going to look to a lack of maintenance and say, hey, the design was fine, construction was fine, it was a lack of maintenance.
Another example, a client, the concrete foundation had some cracks in it, and the owner immediately assumed that there was huge foundational issues, this building wasn't structurally stable. The issue turned out to be just normal settling, no real issue, no defect. Defective design is another defense that is commonly raised if a contractor is confronted with an alleged construction defect.
Yeah, there's something called the Spearman Doctrine. It was developed a number of years ago in the context of federal contracting, and it essentially states that the owner warrants the sufficiency of the plans and specifications. That is, the plans and specs are sufficient to allow for the building to be built. And if the contractor follows the plans and specs and delivers a building or whatever it is in conformance with those plan specifications, and there's a failure, that failure is not on the contractor. The contractor is only the contractor. It does not warrant the sufficiency of the plans and specifications. So this doctrine was developed a number of years ago in the federal context, but almost all jurisdictions now follow that, even if it's not in the name of the Spearman Doctrine, it is followed. The contractor is only responsible for what's a reasonable examination of the plans, specs, and the site. It does not warrant anything beyond that. What often comes up, though, in the context of the contractor reasonably relying upon the plans and specs is even if there's a problem with plans and specs not conforming with actual job site conditions, or there being an obvious hole in the plans and specs, is the contractor's ability to do pre-job inspections, site inspections, all before throwing in its number. If the as-built aren't, and by that I mean if the as-built really are inaccurate and don't conform with on-site conditions, then what often comes up is a potential defense where, well, you should have known that. If the contractor had the ability to do pre-site inspections and did not pick up on that conflict between on-site conditions, as-built, and contract documents, then the contractor may potentially own that. I have a case right now that's active where the contract documents did not pick up on conditions above the ceiling. And it's a pretty large building, multiple floors. And the defense that the owner and the architect are raising said, hey, you had the ability where you had inspections, site inspections, prior to putting in your final number. And they were absolutely correct about that. There was the ability, and we did walk the site prior to putting in our final number. But we also have in writing that we are prohibited from looking above the ceiling. So that prohibition means that there's no way we could have or should have known of what I'm saying is a hidden condition. That the only thing we can do is fall back on the as-built and the contract documents, none of which revealed the conditions behind the ceiling. So be aware as to what the Spearn Doctrine is. Be aware as to what it is you have the ability to inspect and not inspect, and document what it is that you're not allowed to do.
And then the bottom point about the difference between the design spec and a performance spec is going to dictate whether it's in the contractor's wheelhouse or the designer's. To go back to the sewage pump example, if the design specified a particular sewage pump and the contractor bought that, that is going to be a design spec. That is the designer calling out something. Contractor is not responsible for the faulty pump at that point. If the specs call out a pump that has X amount of suction, and then the contractor goes out and tries to buy that pump itself, that is going to be a performance spec, and a performance spec is on the contractor. Contractor is responsible for not delivering the thing required by the contract document.
And that's the standard, and that's the argument. Now, of course, if there's a performance specification, picking up on the pump example, if you're supposed to move a certain amount of water, that's a performance specification. And you go through the submittals, and the submittal you wind up with this one particular manufacturer, and the owner and architect and engineers are signing off on that particular submittal. Depending upon the paper trail leading up to that submittal, you may have some arguments if there is in turn failure.
Everything we're saying in this presentation is stated generally. Every case is a case-by-case basis. The facts are going to change. The arguments you can make, and while we work within this framework, it's always about what happened on the particular project at issue. Mitigation. Lane, what is mitigation?
All right, mitigation is if you're aware of a problem and you take no action to address that problem, and that problem or the damages arising from that problem grow or expand, then you have breached your duty to mitigate. You have a duty to make an effort, a reasonable effort, to mitigate your losses. Real life example, I had a contractor whose scope of work included green roof. We had litigation with the owner. The owner became aware of water penetrating the roof, pouring down into the building, didn't take action to address that penetration, no temporary fixes, temporary patches, anything for that matter, didn't take any action to mitigate or even bring litigation for years. So as a result of that, you had not only the water damage, you had the resultant mold, and what could have and should have been a very small fix expanded to something a lot larger, but that lot larger the owner wound up eating because it did not mitigate its damages.
Spoliation. What is spoliation?
All right, spoliation is the destruction of evidence. It doesn't necessarily mean the intentional destruction of evidence. That is, hey, we found something, this is harmful to us, let's get rid of it. Instead, it could be, with all good intentions, a problem arises, one goes to address that problem, and through addressing that problem, destroys what would be evidence. It could be within the context of doing destructive testing, replacing something, or a reinstallation. If there's a destruction, then that's spoliation if you did not provide notice to the other party. So why is notice necessary for the other party? Well, one, they may have the opportunity to address whatever that problem is. Two, if you don't notify the other party and you go and take action, then evidence that may be relevant to that other party's defense is gone, and you can't recover that. So the implications in court or in arbitration, if there is a finding of spoliation, are significant. Case can be dismissed. There could be something called an adverse inference, which is the arbitrator or the court or the jury take an adverse inference as to your actions, and that oftentimes is can ruin a case, or evidence can be precluded. So if you spoliated something and you want to argue something related to what was spoliated, you're not going to be able to present that evidence.
Like, for example, let's say you have a dispute where there's 10 items at issue, and one of the items is an HVAC system. The owner repairs the HVAC system, throws it away, the contractor never gets investigated, and because of that, can't put on a case to say that this HVAC system wasn't faulty. Court may just simply throw out that component of the claim, that item, and say, the owner destroyed it, there was no opportunity to look at it, gone. And interesting enough, the last point we were just on is mitigation. The owner has a duty to take affirmative action to correct their issues, but this is in tension with the spoliation issue. You don't want to go too fast and, as a result, spoliate any evidence. So just to reiterate, notice and opportunity is a very important point. Give notice, give somebody an opportunity to look at it, if not cure it, and that way everybody is cued into what the issue actually is.
I've never had a case where there has not been insurance defense counsel who says you spoliate evidence, you failed to provide notice, or, and we'll talk about this in a moment, whatever remedy you are seeking is betterment. Those are three standard defenses that arise on every case. And Matt's point, I think, is well taken, that there's a little bit of a tension between your duty and obligation to mitigate and your duty not to spoliate. So there's a bit of a balancing act that needs to be had there, and insurance defense counsel are primed to point out that tension.
So Lane mentioned betterment. Betterment is a very simple concept. More or less, the fix and the costs you're seeking in a case are better than what you originally contracted for. If I ask for stucco siding is an issue, I'm entitled to get stucco siding. I'm not entitled to get something that is double the costs. That's simply all that betterment is. If I ask for PVC pipes in the original plans and specs, the PVC pipes are defective, I'm only entitled to new PVC pipes. I can't get copper pipes. And on that point, final defense is economic waste. Final defense that we're discussing, at least. Economic waste means that the proper measure of damages is the lesser of the cost to repair or the diminution in value. How much is the end value of the thing that is made reduced by the defect? To go back to the copper pipe PVC example, if the specs called for copper pipes, but PVC was installed and walls were put up around it, and to fix it would require tearing down the walls, putting in new pipe, and then re-putting walls up, and yet there is no material disadvantage to the function of the pipes in the first place, the pipes still work, then a court would be inclined to say, you are not entitled to the repair cost there. You are entitled to whatever the difference is between those copper pipes and those PVC pipes.
All right, we only have 5 minutes, so let's jump on over to the two perspectives and try to wrap that up.
Go ahead, Lee.
All right, so all that leads into two real-life examples that Matt and I have had. One's from the perspective of the owner, and the other one's going to be perspective from the general contractor. And I'll try to make this quick since we don't have a lot of time, and if anyone has questions, feel free to follow up with either Matt and I. Our emails on the first slide. When you have any construction defect, you obviously need to understand from what perspective you're coming from. In this particular scenario one, I got a call from an owner who asked me to review a contract, and the contract was for remedial work. Because there was punch shear that was discovered of a pool. The pool was set atop of a parking garage, and punch shear is a structural engineering term of art. Basically, it means that the structure is shearing through. So the pool was falling through the parking garage. Fortunately, this was discovered prior to there being a catastrophe. And what the owner did was came to me and said, "Hey, Lane, listen, we found out about this problem. We notified the structural engineer. Structural engineer, in turn, went out, notified its carrier. Carrier came out, did an investigation. They came up with some remedial scope of work. They developed that scope, the remedial scope. They have a contractor ready to go. We want you to review their contract." Now, everyone here knows that in any capacity, when a carrier is cutting a check, what do they want? They want a release. So the reason why it wound up on my desk was the carrier saying, you need to sign off on the contract and sign the release, and then we're done because we'll fund the value of this remedial contract. So we got to talking, and the owner, after asking some questions, came to the realization that while he'd be releasing the carrier, what if there was a problem with the remedial work? I don't know of anyone that's ever gone into a project where there's not a change order. There was no contingency within that contract. So the owner would be at risk for changes. In addition, there were some concerns when we took a look at this scenario that the remedial design did not go far enough. And when you start to ask some questions, the owner came to the realization that, well, while ideally perhaps the funding for the remedial work would be covered if there was not a change order issued and no extras, but there were other damages that were left on the table there. What do I mean by that? Well, this owner here was fortunate enough not to have a waiver of consequential damages. So you had, as a result of the pool fouling, people canceling their leases. And you would literally see when you went to the lease records the reasons why, because the owner was sophisticated enough to have a reason why section in the notice, and they say no pool. So that's a damage there. In addition, the owner lost income because of parking spaces. This was a parking garage, and when there's spaces below a pool that may be shearing through and collapsing, you don't put anyone below that. So that was lost income, a significant income. So ultimately, you had to develop a theory of liability here that would get the owner full recovery. The problem was here that the structural engineer didn't have the exposure here, the damages exceeded the policy. So the proceeds were not enough to cover the damages, and that's when you have to get creative or think outside the box. So you look beyond the structural engineer and develop theories of liability to recover as much as you can there. And that's what we did here. We took a look at not only a structural engineer, but the general contractor, the pool contractor, and everyone that touched the different scopes of work that involved the structural components. And from there, we were able to leverage, and that's what it's about. It's about leveraging a resolution that made the owner as whole as possible. Now, this is what was the one walk away from here, and I'll move to the next one, is this is after substantial completion, after final completion, I should say, and the owner's not holding any money. At that point, the owner, of course, doesn't have any leverage. That has to be contrasted with the next scenario where the owner did have leverage and a problem arose. This particular instance represented a general contractor, and during the course of the project, there was significant water intrusion, but that did not come into a head until after substantial completion. That point in time, though, the owner had not funded retainage nor the application prior to that. So the general contractor had to make a decision. Is he walking away from the project since he was not getting paid, or is he going to be proactive in an attempt to mitigate its own exposure? Took the latter step. Not all people can do that because you have to self-fund there, but they were large enough to be able to do that in order to control its own destiny. And what I mean by that, if you walk away from a project and then you're at the whim of the owner or the general contractor, remember it may be engaging a replacement contractor. The replacement contractor is not going to be familiar with the job site. There's going to be a ramp up, and oftentimes it's going to be on a T&M basis rather than a complete scope. So you, at that point in time, are defending rather than chasing. So there's a strategic component to addressing construction defects. In this particular situation, the general contractor developed a remedial scope of work in conjunction with the owner, then completed that scope of work and was able to leverage through looking at different subcontractors' insurance provisions, developing a target because some of the insurance provisions did not have adequate coverage. Some of the subcontractors went out of business, and was able to develop a target to be able to chase down a full recovery for its remedial costs, which were substantial. And recovery of those remedial costs, and I'll wrap it up right here, was based upon recovering from a particular subcontractor that we were able to make a target, and the pollution policy that Max spoke about earlier, because when you have water intrusion, what do you have oftentimes? You have mold. So we were able to, through very specific cost coding, keeping good records, make a recovery under the pollution policy, and look to the subcontractor target for the rest, and this general contractor was made whole. So the walkaway here.
Well, notice and documentation is very important. Preserves evidence, allows early resolution, probably required under the contract. It's important to investigate. If you rely on people who are participants, if an owner relies on a GC to investigate, the owner risks the GC having a bias in favor of no defect. If a GC relies on an owner to investigate, there's a risk that the owner is going to exaggerate the claim. However, investigation is important. It's always a good idea to get third parties help in that. And as we noted earlier, testing costs could be recoverable in that. And finally, if you're a contractor and you find yourself with potential defects and the owner asking you to come back and fix them, in your best interest to fix them. You're going to be able to do it cheaper than anybody else, and you will avoid having the owner take a leverage position and potentially coming after you for more costs. And with that being said, you can always go after your subs. You can always go after insurance. There's always many avenues, and the owner as well for no defects. And finally, just as a wrap up, I know David Kane has a question real quick. He says, what's the difference between consequential damages and actual damages? Actual damages are direct costs related. If the HVAC is defective, an actual damage is the replacement cost of the HVAC. Consequential damages are costs that are consequentially related. If we can't use the HVAC, we can't open the building, we can't have tenants, no rent, that's the consequential damage. Down the line, and it's not necessarily directly connected to that cost.
Which may or may not be recoverable depending upon the terms of the bond.
So, Q&A, if you have questions, feel free to email us. Our email addresses are right here. And note from this, these are all general points, but every construction case, dispute, project, as you know, is fact dependent. They're all different. There's no cookie cutter. Different participants, different claims, different circumstances.
And I'll leave you with this. The construction defect cases are costly. They are time consuming. And if you have the mindset to be proactive and the other parties are likewise of the mindset to be proactive, you can mitigate a lot of that cost and a lot of that time if you want to problem solve. So early intervention is, I think, the best way to try to mitigate those costs. Feel free to, if anyone has any questions offline, to follow up with our emails. And if not, hope everyone enjoys lunch.
Take care.